Hi, my name is Sesan Suliaman. I work in the tax practice group of TEMPLARS. Recently, a decision has caught the attention of most Nigerians, especially in the business and tax sectors. That decision is one that was given by the Federal High Court of Nigeria, which addressed value-added taxation and the constitutionality of otherwise of the collection of same by the federal government of Nigeria. So today, I'll be discussing that judgment with a seasoned tax expert, Dr. Jude Odinkonigbo, who is a counsel in TEMPLARS. We hope you tune in and listen and enjoy our discussion. Thank you. So, Dr. Jude, we're here to discuss a very topical issue, and it's one that has been going around the circles, legal and business. One that affects VAT and other forms of taxation in Nigeria. It's the one that I'm talking about the recent decision in AGRS versus FIRS, where the court made some very, very important decisions that would affect our landscape going forward. So can you give us a highlight of that decision briefly?
Okay, truly that was a very interesting one and also controversial.
Right.
It is controversial in the sense that it touches the purse, the financial, the pockets of federal government and perhaps that of the state government. The point is that in Nigeria, there have always been that struggle over financial fiscal jurisdictions of the two levels of government, the federal government and state government. So Rivers State in this case actually went to court to challenge the authority of the federal government through the FIRS, that is agency, to collect value-added tax. Rivers argued that the federal government does not have the power or the authority under the Constitution to collect VAT. The value-added tax, and that means lead us briefly to just consider the history of the value-added tax. The Value-Added Tax Act used to be a decree that the military promulgated during the military administration, I think sometimes in 1993 or about. So, however, when the military were leaving the Abu Salam regime, they inserted the section 315, which is the existing law clause. This existing law clause saves all the existing laws, like decrees and edicts, provided that it satisfies the condition under section 315 and also is not inconsistent with the provisions of the Constitution in any way.
Right.
So the Rivers State government argued that looking at the exclusive legislative list, which is the list that only the National Assembly could legislate on, the State House of Assembly and the State House of Assembly is not expected to legislate in that area, that there's no item anywhere the value-added tax was mentioned or listed there. However, the federal government was arguing that that was an existing law, and in fact, there are certain provisions under the Constitution that this could be deemed to be heads that the National Assembly could legislate on, for instance, under Trade and Commerce Clause in Item 62, or incidental and supplementary matter under Item 68.
Right.
You know, so, and even Item 60A, which is a fundamental objective and directive principle of state policy, Chapter 2 of the Constitution. However, the court, in the end, held that it had looked through the provisions of the Constitution, especially the exclusive legislative list, and did not see anywhere the value-added tax was mentioned. And to that extent, that the federal government does not have the power to collect VAT. It also added education tax, technology tax, and the rest. But you know, our interest is on VAT for now. That is number one. Two, the court held that looking at Item 7 of the concurrent legislative list, which is the concurrent legislative list is the list that both the National Assembly and state government could as well, legislate on, that the National Assembly could only exercise that power of delegating the power to collect any of those taxes mentioned. Of course, there's no new head of tax in the concurrent list, but the Item 58 stamp duty, Item 59 income tax, that the personal and corporate and capital gain tax under exclusive list that were brought into the so that the federal government, the National Assembly could only authorize the state government or any of its agencies to collect any of those taxes, save companies' income tax. That was actually the decision.
So this is a very laudable decision in terms of I think the courage of the Federal High Court to make this kind of decision that affects...
It was very courageous of the judge. I think Honorable Justice Stephen Palm.
So would you say that there are any positives that comes from this decision?
Well, the positive is that the advocates of fiscal federalism are actually happy because in a true federal system of government, the powers need to be shared. There are boundaries, legal boundaries that the particular government does not cross, it's not expected of the federal government to go into residual matters in a typical federal government, government. So, and also, the state government does not need to go into the exclusive legislatively. So, any of the areas that the National Assembly has been empowered to make kind of law. So, the advocates, the proponent of fiscal federalism, which all federal students, would want in a federal state, are happy because some people are saying, oh, Nigeria is actually being run like a unitary state.
So this is sort of a confirmation that the Constitution aligns with this, and the judge has brought us within that
exactly.
concept. Okay, so other than that, I think the shortfalls have been the ones that have been more talked about. What, I guess, important shortfalls do you think the
there are important shortfalls. We'll actually examine this in details in our newsletter, but I'll just highlight one or two things. One is that decision, the court was wrong to have said that it is only in item 58 stamp duties, item 59 income tax, personal and corporate tax and capital gains that the National Assembly could legislate on.
Right.
The court did not consider item 16, which is on custom and excise duties. It did not consider item 25, which is on export duties. So these are areas that the National Assembly could legislate on, and federal government could as well collect the taxes.
Addressed in the judgment.
So even one could as well go into trade and commerce clause under 16 item 62 or incidental and supplementary. But some people will some people may argue that even if it's going to be incidental and supplementary, it must
be related
to a particular a particular head. So, and again, the court failed to appreciate what withholding tax is. With all due respect, it treated withholding tax as a form of taxation. Withholding tax is not a form of taxation, but a means of tax collection. So if he says that the federal government does not have the power to collect withholding tax, that means you are countering. The court actually contradicted itself when in interpreting item 7 of the concurrent legislative list, which removed companies' income tax. How will federal government collect income tax without withholding tax? Withholding tax is just an advanced means of collecting taxes. Again, the court did not consider the decision of Attorney General of Ogun State and Aberaba, where the court distinguished separated intrastate transaction on one hand and interstate and international transaction on the other. In that case, the court held that a state government has the power, Ogun State in this case, to enact laws like sales tax and also collect intrastate taxes on intrastate transactions. But when it comes to interstate transaction and international transaction, that only the federal government can collect that. And this is an interpretation of the Trade and Commerce Clause contained in item 62A of the exclusive legislative list.
Okay, that's quite interesting actually.
So, but we examined a lot of things in our newsletter. So whoever is interested could get the newsletter.
Of course, I'm sure this definitely spikes a huge interest.
So so I will ask, having looked at this, there are other things that people, will have to look at. For instance, administrative issues. Assuming if the court, because it's likely this matter may get to Supreme Court.
Oh, definitely.
And it gets to Supreme Court, and the Supreme Court decide to, follow the decision, its decision in Ogun State and Aberaba. How will this be administered?
Yes, thank you for that, Dr. Odinkonigbo. This is really, for me, a major issue if this were to go all the way and be upheld. This is because currently we have a system where we have the FIRS and the state's revenue authorities, and one wonders exactly how the collection is going to be done. Is Nigeria going to liken its own system to other jurisdictions which have FIRS being the federal authority, being the collection authority, which then remits to the state government? Or does it say that each taxpayer has to do the taxes to the relevant authorities by itself? Which, of course, you have to ask yourself, is that not making our ease of doing business issue even worsened? Because currently Nigeria suffers from a low ranking. So if a prospective businessman wants to look at Nigeria, would they not be asking themselves questions of, we've made compliance even more difficult.
Exactly.
We've also raised the question of possible double taxation. Exactly. So I think this is one which the Supreme Court will have its work cut out for it when it comes to making the decision. So it will be interesting to see what happens when we get there.
Thank you.
Thank you very much for this conversation. This has been very wonderful. Thank you.
Thank you.
So thank you everyone for watching. We As you've heard from Dr. Jude and myself, this has been a very important decision in the Nigerian business and tax landscape. We look forward to seeing where the Supreme Court lands on either side of the divide. We definitely will keep you updated in that regard. So once again, my name is Sesan Suliaman.
Thank you. I'm Dr. Jude Odinkonigbo.
Thank you. Bye.